This is a written agreement that was created to achieve mutual rights and obligations. The Law of Treaties was initially based on customary international law and now largely codified in the Vienna Convention on the Law of the Treaties 1969, which is VCLT. It contains the Law of Treaties governing the creation, operation, and termination of treaties. It came into force on 27 January 1980. Other name for treaties is covenant, convention, charter, statute, general act, protocol, agreement, exchange of notes or letters, and modus vivendi. This is consent. There are four concepts, which is set of signature in Article 12, consent of exchange instrument, Article 13, ratification, Article 14, and accession, Article 15. Reservation. This means generally that where a state is satisfied with most of its treaty but is unhappy about one or two particular provisions, it may, in certain circumstances, wish to refuse to accept or be bound by such provisions, while consenting to the rest of agreement. By this device of excluding certain provisions, states may agree to be bound by a treaty which otherwise they might reject entirely. This obviously may have very beneficial results in the cases of multilateral conventions by inducing as many states as possible to adhere to the proposed treaty. To some extent, it is a means of encouraging harmony among states of widely differing social, economic, and political systems by concentrating upon degree, basic issues, and accepting disagreement on entirely other matters.
Then we will talk about the next flow of Law of Treaties, which is entry into force. Basically, it consists of few processes, and I briefly explain one of them. First of all, educating of negotiator. It is mean once a state has decided to create a treaty, it is necessary that such representative should be fully accredited and given sufficient authority to conduct negotiation, conclude and sign the final treaty. Secondly, is to have negotiations and adoptions. The negotiator will maintain the contact with their government and usually, before signing a treaty, they will obtain a new set of instructions indicating the manner of the signature. The text is adopted by the consent of the parties. Based on this, a common practice over recent years has been for the final text of the multilateral treaties to be adopted by meetings of the reference international organization, for example, the UN General Assembly. Thirdly is authentication, signature and the exchange. In this process, after the text of treaty has been agreed upon and adopted, the treaty is ready for the signing. For the effects of the signature depends upon whether the treaties is subject to ratification, acceptance or approval. If this is the case, then the signature means no more than the delegate have agreed a text or have referred to their government of approval or ratification. Next is ratification. It only implies of necessary for the delegates to refer to the treaty back to their government for approval. Ratification is the approval by the head of a state or government of the signature of the treaties. In the Article 2 VCT 1969 define that ratification as an international act whereby states established on the international plane consent to be bound by a treaty. After that is accession and the adhesion. In this point, where a state has not signed a treaty, it can only accede or adhere to it. Accession or indicate that a state is to become a party of the whole treaty, whereas adhesions only involve acceptance of the part of a treaty. Then the entry into force happen. When a treaty is entered into force, it depends upon its provisions or upon what has the party may otherwise have agreed. The last one in the entry into force is registrations and publications. For actual example, in Article 102 of the United Nations Charter, it provides all the treaties entered into by members of the United Nations shall, as soon as possible, be registered with the Secretariat of the United Nations and be published by it. Now, I will explain the next element in the Law of Treaties, which is the reservations. Based on Article 2 VCT 1969, define reservations as a unilateral statement somehow paste or name made by a state when the signing, ratifying, accepting, approving, and acceding to the treaty, whereby it purpose to exclude or to modify the legal effect of the certain provisions of the treaty in their applications to the state. Applications of the treaties. The doctrine of the Pacta Servanda, the rule of the treaties are binding on the parties and must be performed in a good faith. It is a fundamental principle on the international law, and is also mentioned in the VCT 1969 Article 26. Under this, there is no retroactivity, territorial application, successive treaties and the third parties. Move forward, we will be discussing about the amendment and the modifications. The VCT 1969 draw a distinction between the amendment and the modification. The treaty interpretations mean the text of the treaty has been agreed. There can remain considerable dispute about the precise meaning of the specific clause. It is therefore necessary for there to be a certain rule repeating to the treaty interpretations. And the last but not least, the treaties are often drafted in the two or more languages. In this case of the bilateral treaties, a normal practice is that the treaty text should be drawn up into the two languages of the parties, both texts being equally authentic. If a number of texts are equally authentic, they may be read in conjunction in order to ascertain the meanings of the convention.
An error can nullify the state consent if that mistake relates to a fact assumed by the state to exist and form an essential basis of its approval to be bound by the treaty. However, if the state knew or contributed to the error, it cannot invoke the ground to free itself from observing the treaty. Fraud or corruption. A state consent to be bound by its treaty is a result of fraud or bribery conducted by another state. Coercion is another ground that a state may invoke to nullify a treaty where it was forced to sign the agreement under military pressure or use of force. The lack of authority is the fourth ground of invalidity, where negotiators act outside the instruction or violate national treaty-making rules. Another factor is the treaty breach of peremptory norm, while the other ground concerned a problem with how the treaty was concluded. The Zukagan ground focuses on the treaty subject matter. Hence, a treaty concluded between two countries to commit genocide or torture will be void. In all cases, the invalidity of a treaty renders it void and without legal force. The difference is that relative grounds render a treaty voidable. Therefore, the innocent treaty can affirm the treaty or to terminate it, whereas absolute ground automatically render the treaty void by law, as it has no legal effect from time it was born. While both ground leads to the invalidation of the bilateral treaties, the existence of relative ground in a multilateral treaty affects only the state concerned and not the other remaining parties. First one, agreement. A treaty can be terminated under the consent of all the parties after consultation with the other state. A party may also withdraw from the treaty under the same conditions on termination. A right to absence of provisions withdraw from a treaty is usually to be applied upon not less than 12-month notice. Second, material breach. For an innocent state to terminate a treaty, the breach by the state in default must be material. A material breach invoked by a state as a reason for termination in whole or in part, especially when the breach is a violation of a provision crucial to accomplishment of or purpose the treaty. Third, the impossibility of performance means there is destruction of an object essential for the treaty's execution, provided that it is not caused by the state invoking it. Fourth, fundamental change of circumstances and where the treaty conflict with a new peremptory norms of general international law. A multilateral treaty does not terminate because the number of parties falls below the minimum necessary to bring it into force, unless it so provide is a treaty terminated by severance of diplomatic or consular relation. The Temple case. ICJ has rejected Thailand's argument that particular map contained a basic error and therefore it was not bound to observe it, since the play of error cannot be allowed as an element violating consent if the party advancing it contribute by its own conduct to the error or could have avoided, or if the circumstances were such as to put that party on notice of a possible error. The court felt that in view of the character and qualification of the persons who were involved on the Thai side in examining the map, Thailand could not put forward a claim of error.
In 1977, Hungary and Czechoslovakia signed a treaty to construct a dam. In 1989, Hungary abandoned the project, but Czechoslovakia continued construction work. In May 1992, Hungary notified that Czechoslovakia that it was terminating the treaty.